May Lordship. My Lord, I beg to mention item number 20.
Yes.
Item number 20 may be allowed, my Lord, for
Yes.
adjournment for, my Lord, 3 weeks.
After 3 weeks.
Yes. My Lord, because there is some, they are supposed to get settle the matter outside the court.
Some settlement.
Yes.
Okay. Head Learned Counsel, Mr. Such and such, your name.
Tison,
You're appearing for petitioner.
petitioner.
Appearing for the petitioner, praised for listing the matter after 3 weeks as some out-of-court settlement is being contemplated. Stop. Accordingly, list the matter after 3 weeks. Yes.
Much obliged. 19 also, my Lord. 19 and 20 same.
Analogous.
Yes.
Okay.
One additional affidavit
Huh.
which could not be possible today. So further, at least 2 weeks time may be granted, Your Lordship. I have informed the other side also,
Okay. Heard Learned Counsel for the petitioner, Mr. You are A.K. Singh.
Lordship.
As he's unable to contact the petitioner. So prayers allowed, list after 2 weeks. Yes.
Your Lordship,
Yes.
Your Lordship, I'm mentioning on an unlisted item, Your Lordship. Your Lordship,
What's the urgency?
Your Lordship, I'm praying for Your Lordship withdrawal of the criminal petition, Your Lordship, and liberty to file
File
afresh, Your
afresh.
Lordship.
Okay.
Your Lordship, may kindly list the last, Your Lordship.
Yes,
Today-
yes.
today-
It will come up. You have already filed.
Pardon?
You have already filed it.
Yes, yes. Motion has already been done, Your
Ah,
Lordship.
Yes.
Applies.
May I please, my lord? My lord, I beg to mention item number 4, my lord.
Yes.
My lord, can it be listed after 2 weeks, my lord?
You are for the petitioner.
Yes, I am for the appellant, my lord.
Appellant. Oh, RSA.
Hmm.
Okay. No, any objection?
No, my lord, I am for the respondents.
Head Learned Counsel for the appellant, Mr. Such and such, who prays for listing the matter after
3 weeks, my
after
lord.
3 weeks. Stop. The prayer is not objected to by the opposite party. Stop. Accordingly, list the matter after 3 weeks. Yes.
Okay, deeply obliged.
My lord, I beg to mention item number 8, Your Lordship.
Hmm.
On behalf of the respondents.
Okay.
My lord, the leading counsel, Mr. Deep Panging, is not here today, Your Lordship.
Hmm.
Can this be can be listed on 12th of February?
12th February.
Yes, Your Lord.
Heard Learned Counsel for the respondent, MS such and such, who makes a mention on behalf of the leading counsel, Mr. D. Panging, who is out of station today. Stop. It is prayed that the matter may be listed on 12/2/2026. Stop. The prayer is not objected to by the Learned Counsel for the petitioner. Stop. Accordingly, list on 12/2/2026. Yes.
My lord, there is an interim order that may be continued.
Okay. The interim order passed earlier shall continue till the next date.
Much of
Yes.
Your Lordship, I also beg to mention item number 21, Your Lordship. Here, Mr. Panging is appointed as amicus curiae and he's appearing on behalf of the victim.
Hmm.
Since he's not here today, can this matter be listed on 2nd of coming month, Your Lordship?
Monday.
Monday.
Heard Miss such and
Madam,
such.
we are also appearing in the matter, my lord.
Huh.
I'm for the one of the accused persons, my lord.
Okay.
My lord, today matter has been fixed, is consented by all the parties, my lord, the representing respective, my lord, the accused persons, my lord.
Hmm.
My lord, because of the pendency of this, my lord, the Somoto case, my lord,
Hmm.
the trial is not proceeded as per the, my lord. So therefore, my lord, the on consent, my lord, matter has been fixed for final, my lord, the disposal today.
Hmm.
My lord, maybe my lord, they're having some other my lord, the personal difficulties. Most of the lawyers are not representing the council are not present today, my lord.
Hmm.
Now, my lord, the matter may be fixed on certain day. There is agreed by the parties. On which date, my lord may kindly observe one thing, my lord. In the absence of the counsel for the respective accused persons, my lord, the matter will be heard my lord, further, my lord, for disposal. Otherwise, my lord, altogether, my lord, my lord,
How
what you have seen,
many councils are there?
my lord, if, my lord, we go back counting, my lord, it seems more than 30, my lord.
More than 30.
My lord, it seems, my lord. So, my lord, on consent of the other parties, my lord, when the matter is fixed, my lord, the keep on, my lord, the adjournment on the, my lord, the several other grounds is, my lord, prejudice the, my lord, the proceedings, my lord. So therefore, my lord, the on consent matter may be fixed for certain date, on which date, my lord, the individual shall be made to dispose of the matter, even if, my lord, the counsel for the other parties are remain absent, my lord. My lord, accommodation that way, my lord, is not possible,
No,
my lord.
the
That's because,
question is whether the pleadings are
my
also
lord, everything is completed, my lord. It is suo motu case. Some has already filed their affidavits, and some has not, my lord, decided, my lord, as it is already recorded, my lord. They opt not to file, my lord, any objection, my lord. Now only, my lord, the matter is fixed for the hearing, my lord, and it is required to be, my lord, disposed of, my lord. It's because the, my lord, as I pointed out, my lord, the further trial.
Okay, okay. So today also, I think maybe some of the advocates may not
Exactly,
be
my lord. That is the, my lord, whole difficulty, my lord. On the last occasion, this occasion, my lord, on several occasions, my lord, this matter is, my lord, adjourned. So therefore, my lord, at this stage, my lord, what I am praying for is, my lord, let us have a date on which, my lord, the endeavor shall be made to dispose of the matter, my lord. We are not basically against the, my lord, the adjournment, my lord. Now, my lord, it has to be, my lord, concluded, my lord. Otherwise, it has to be, my lord, decided, my lord, disposed of, my lord.
heard learned counsel, MS such and such, who makes a mention on behalf of Mr. D. Panging, who's appearing. Oh, who's Mr. D. Panging? Okay, okay. Who's appearing as amicus for on behalf of the victim. Stop. It is submitted that the learned amicus is presently out of station, and it is prayed that the matter may be listed on 2nd February 2025.
Lordship, that may be kindly fixed on.
However, it is submitted by Mr. M. Kato appearing for, you are appearing for
My lord, the one
our
Bulang.
respondent.
respondent number one.
For respondent number 1 submits that there are several respondents in the present case, and there are about 30 counsels who are appearing in the matter, and it would be difficult if the court and it would be difficult for the court to wait for all of the counsels to be present on a particular date. And he therefore prays that this court may pass a direction that on the next date fixed, the matter will be taken up for hearing, even in the absence of some of the counsels, as it is, as the matter requests expeditious disposal. It is stated that due to the pendency of this petition, the trial has been held up before the trial court. So, any objection to this?
Your
Do
Lordship,
you have a fixed date?
that may be
to
fixed on
dispose
6th of February.
6th?
Yes.
No objections. Your Lordship.
Only with the consent of the for all the councils present today, the matter is fixed on 6th February for hearing. On which date an attempt will be made to dispose of the matter. Yes.
Lift up.
Yes. You just, all of you, you just give your names. To the, yes, the state respondent is represented by Mr. M. A. Taylor, an additional public prosecutor, and respondent number such and such represented by, and then you just put all your names, okay?
Madam.
Just give your names in a slip of paper.
Develop.
Yes.
Item number 1.
May I please?
Yes.
Your Lordship, this is an application under 528
Hmm.
for the crossing and setting aside of the order dated 2025, passed by the learned district and session court, Your Lordship, whereby the criminal revision petition filed by the respondents has been allowed, and the maintenance amount of rupees 10,000 has been altered to rupees 30,000 per month in respect of the respondent number 2, Your Lordship. The fact of the case, Your Lordship, is that, Your Lordship, the respondent number 1 is the second wife of the petitioner, Your Lordship. They have solemnized their marriage as per the Galo customary. And with the marriage, Your Lordship,
Respondent 1 is second wife.
yes, sir. second wife. And the respondent number 2 is a child born out of the marriage, and this child has been born out of IVF, Your Lordship, in vitro fertilization, Your Lordship. And this IVF has been done without the consent and the knowledge of the petitioner, Your Lordship.
Mm.
However, out of love and affection, Your Lordship, the petitioner, who is the partner, has accepted the child, Your Lordship. And this respondent number 2 was born in the year 2011, Your Lordship. Thereafter, without any having judicial separation or divorce, Your Lordship,
Mm.
the respondent number 1 is living separately.
Mm.
And in the year 2016, Your Lordship, they have filed one maintenance case, Your Lordship. And by
Let's see the impugn order.
impugn order, Your Lordship will find at page number, Your Lordship, 37 onwards, Your Lordship. And the operative portion, Your Lordship,
This,
is in page number 63. May I read the one?
wait.
Your Lordship, kindly, there is page number 63, Your Lordship, paragraph 48,
Mm.
the order of the learned district and session court, Your Lordship.
60.
3, Your Lordship.
Hmm.
63, Your Lordship, married, Your Lordship. In the circumstances as mentioned above, this court is of the opinion that the impugned judgment and order dated 23/11/2023 passed by the Honorable Court of Chief Judicial Magistrate Alo in which case number 73/2020 in main maintenance case number 04/2016 does not suffer from manifest illegality. The observation of the learned district and session court is that there was no manifest error or illegality, Your Lordship. However, Your Lordship, district and session court has interfered with it. If there is a no manifest illegality, then how the court can interfere in the order passed by learned district, learned CGM court, Your Lordship. The fact is that, Your Lordship, they have filed earlier maintenance case, Your Lordship, which was disposed in the year 2016 itself, Your Lordship. Kindly Ferus, Your Lordship.
So in the initial order
Yes, Your Lordship.
by the CGM, how much was given?
10,000 along with the educational fees of the minor child, Your Lordship.
Hmm.
And still I'm paying. Your Lordship, I have many other obligated dependent to be maintained, Your Lordship. And however, in the case of the respondent number 1, Your Lordship,
Hmm.
she is presently serving as APO, Assistant Project Officer, Your Lordship, and she is earning handsomely, Your Lordship, more than around 150 lakhs, Your Lordship. And moreover, Your Lordship, besides that, she is collecting rent, Your Lordship, from 2 RCC buildings, Your Lordship, which has been bought and constructed jointly, Your Lordship. And these things has been suppressed by the respondent number 1 while filing the maintenance case before the learned trial court, Your Lordship. These things has not been taken into consideration, Your Lordship. She has no any other person to be maintained except herself and the minor child, Your Lordship. It is a settled law that when mother is working and earning,
No, you just take the court to the part where the reasoning is there, the reasoning of the trial court, not just the operative portion, because there has to be some reason on which the order is based.
it is in 64 years old. It
Well,
64, Your Lordship, page number, Your Lordship.
Oh.
There is no any specific reasoning has been made, Your Lordship, in this matter, Your Lordship. 64 in view of the material available with the case record and argument put forward by both land council. This court opinion that the applicant could make out the case. Hence, the revision application is hereby allowed and by altering the order dated 16/2017 in maintenance case, Your Lordship. In main maintenance case, Your Lordship, I was paying rupees 10,000 along with the educational expenses of the child, Your Lordship. However, they have filed one miss case, Your Lordship, after disposal of this order, Your Lordship.
No, see parad 43. No doubt the amount of monthly maintenance of rupees 10,000 was passed when the revisionist number 2 was just above 5 years.
Yes, Lord.
And now, having attained more than age of 14 years, definitely his needs and requirement has grown. and it is definitely insufficient for the sustenance of revisionist 2. So that is one of the reasonings.
Your
That
Lordship,
when the order was passed, the revisionist 2 was only 5 years old, and now he's above 14 years, and therefore his needs and requirement has grown. So that is quite a reasonable.
Your Lordship,
finding.
kindly appreciate the order of the learned CJM, Your Lordship, whereby the miscase
Because,
filed by the
because an order of maintenance can always be reviewed, it can be altered with the change of circumstance.
Yes, sir, that is
Okay.
there, Your Lordship, but kindly there is the observation made by the learned CJM, Your Lordship.
See, with the growth of respondent revisionist 2, and with the increase in the salary of the respondent and his position being promoted to the post of chief engineer, definitely there is change in the circumstances. So what is wrong in that finding?
Your Lordship, kindly appreciate the order of the learned CJM, Your Lordship.
Okay, let's see.
It is page number 28 on Your Lordship. This is the miscase, Your Lordship, filed by the respondent number 1 under 127 CRPC, Your Lordship, for enhancements, Your Lordship, and by Your Lordship, order dated 23/11/2023, this miscase has been dismissed, Your Lordship, being devoid of merit. The operative portion is page number 35 onwards, Your Lordship. May I read, Your Lordship? It is admitted fact that the petitioner number 1, working as a APO in women development and drawing salary of rupees 1,50,000 per month after deduction, and also collecting rent from buildings located near General Hospital Alo and at Hikar Gumin, though earning of rent is disputed and respondent husband had been also working he was earlier working as an executive engineer. He is paying a monthly maintenance allowance of rupees 10,000 per month and paying education fee for petitioner number 2, Your Lordship, the minor child, in terms of direction of this court in this maintenance case number 4 in 2016. Thus, petitioner number 1 is an independent lady and has a sufficient income to maintain herself and her son, Your Lordship. However, the burden of upbringing of child is on both the parents, Your Lordship. And husband cannot avoid the burden merely on the ground that his income is less than that of wife, and others are also dependent upon him. Paragraph 10, the chapter 9 of the CRPC social beneficial legislation to uplift the object of social justice to prevent vagrancy and destitute, to uplift the object of social justice, and not for the purpose of luxury or for extravagance, to defeat the very purpose of social legislation. Considering the fact that the respondent is paying rupees 10,000 as monthly maintenance allowance to the petitioner number 2, and also bearing education fee and keeping objective of the legislation, I do not find petitioner has taken a specific ground for enhancement of monthly maintenance allowance for petitioner number 2, when petitioner number 1, wife, who is earning much more than the respondent and having a secure government job, and also has other source of earning in form of monthly rental from the 2 building, which is not disputed. Accordingly, the present miscase is liable to be dismissed and being devoid of merit. The miscase was dismissed, Your Lordship. And according
Okay, we'll issue notice, but how can you say that 2017, when order was passed in 2017, 10,000? Today, now we're in 2026. How can 10,000 per month be enough for anybody? Can you imagine? 10,000 you must be spending in 1 week only.
No, Your Lordship, he's claiming maintenance for the minor child, Your Lordship. Wife is earning, Your Lordship, and she's
That's
collecting-
why for the minor child also, now he will be going to class 11, 12, then expenses will be more, obviously.
You know, when
It's okay, we'll issue notice at this stage,
Your
but,
Lordship, I'm praying
but
for
no
the extreme
stay,
prayer also.
but no stay.
Your Lordship,
No stay.
to avoid the destitute and hardship, Your Lordship, order of the earlier maintenance case may be continue, Your Lordship. In the meantime, the order of this 30,000, this is overburden, Your Lordship. The mother is using the child as a weapon, Your Lordship.
30,000 is not much.
Your Lordship, there are some other person who are obligated to be maintained, Your Lordship.
You have remarried?
No, she is my second wife, Your Lordship. I have to maintain
Oh,
the
okay,
child for
the
my
first
first wife,
wife.
Your Lordship.
How many children
I have
from the first wife?
3 children, Your Lordship, and they are pursuing education in different colleges, Your Lordship. I have a ailing mother. also.
We'll issue a short notice, but no stay.
I humbly pray, Your Lordship.
Hmm.
Your Lordship, kindly appreciate, there is a
30,000 in this day and age, I don't think it's much.
30,000, Your Lordship, I'm going to be retired very soon. Your Lordship. Only 1 year is
and
given.
you are a high-ranking officer.
It is admitted, Your Lordship,
Yes.
but I have legally obligated to maintain other my child, Your
Okay,
Lordship.
this
I have a ailing
application-
mother also, Your Lordship.
This application under section 528 of the BNSS has been filed, praying for quashing of the impugned judgment and order dated 18/12/2025 passed by the learned district and session judge Alo, West Siang District in criminal revision 2 of 2024, by which the learned district and session judge had allowed the revision and enhanced the order dated, enhanced the maintenance amount to rupees 30,000 per month, which was earlier, which was earlier 10,000 as per month as granted by the learned chief judicial magistrate in maintenance case 4 of 2016. Stop. It is the case by heard learned counsel for the petitioner such and such. It is the case of the petitioner that the respondent number one is an independent woman who is the second wife of the petitioner, and she is a working woman who is earning more than 1 lakh per month.
1,50,000.
1,50,000 per month, and also rent, and also getting rent from a building, from a commercial building.
Yes, Your Lord. Two
From also
assistive
getting,
building, Your Lordship.
also getting rent from a commercial building, and therefore the amount of 30,000 per month is excessive, and therefore this, and therefore being aggrieved by the impugned order, this petitioner has approached this court. Stop. Para. Issue notice returnable within 2 weeks. The petitioner shall take steps for service of notice on the respondent number 1 and 2 by speed post document as well as usual process within 3 working days. List after 2 weeks.
Your Lordship, kindly let me submit one thing, Your Lordship.
Yes, yes.
It is admitted, being a father, I have to maintain my child. But it is a
Yes.
settled law that both the parents have to maintain, Your Lordship. If the amount is 30,000,
But-
it has to be borne by
But
both the
look at
parents,
the
not
time,
only me.
look at the time lapse. 2017, 10,000 was given. So, and now in the year 2026, its enhancement is not much, 30,000 after so many years.
Your Lordship,
So,
Your Lordship, kindly appreciate
what
the
is
fact that
unreasonable?
It is a settled law by the Honorable Supreme Court that when the mother is working and earning, Your Lordship, she is also obligated to maintain the child. Only she is having the custody of the child. It doesn't mean she has a responsibility to maintain the child.
No, she
If
will
the
al-
amount
she
is
will-
30,000,
she
it has
will
to be
also
borne by both the
maintain-
parents, Your
so-
Lordship.
So she will also maintain, no doubt about
No,
that.
so, Your Lordship, it is overburden upon me to maintain the child, Your Lordship.
2 weeks only, 2 weeks, after 2 weeks.
Kindly, Your Lordship, take a note that in the next day.
Okay, okay.
And
On the next returnable date, the court shall consider the interim prayer.
Much obliged.
Item number 3. May it please your ladyship.
Yes.
This is a criminal petition filed under 528
Hmm.
BNS
Hmm.
in connection with Nalagan Police Station case number 5 of 2022.
Hmm.
And the trial proceeding is pending before the Larned CGM Court, UPI.
Hmm.
Here, your ladyship, after entire investigation, and there was also recently an inquiry was conducted against me, and the finding of the inquiry also, I was being proved as not guilty, and no any incriminating documents found from me, and I was exonerated. Even the IO of the case, during time of investigation, he have only arrested me due to some bank statement with the leading accused, prime accused, that is Srimati Sangeeta Bansal. She was the employee in the Director of Health Service. So all the accused persons and the witness, they have never whispered a single word or a sentence that accused petitioner was involved hand in glove in this fake appointment job. So I pray your ladyship that accused criminal proceeding may be quashed, set aside. As he alleged accused person is suffering from pain and hardship since for last 4 years after the registration of this case. And he have fully cooperated, no any incriminating documents found out. Even if I take your ladyship to the complaint filed by the respondent 2, 3, and 4, there is no name of anybody regarding by name.
Acha, just look at your course title.
Okay, page.
Course title. Your course title. You have come to this court, or you have approached the court under what section?
Under 528 BNSS.
This is 528. Just go to your title page.
Oh, Your Lordship, I have made one prayer before, and I have for the correction of the course title.
Mm.
That prayer was allowed earlier hearing.
But after that,
I
you are
think I've
supposed to file the corrected course title.
I have
no?
corrected Your Lordship.
Amended course title. Amended course title is filed.
Yes, I have filed Your Ladyship. There was one order also from the this honorable court, and I was allowed to correct the course title.
Order dated. Okay.
Yeah,
19.
order dated 19/12/2024, Your Lord.
Okay. Yes.
If Your Ladyship permit me, may I read the FIR,
Mm.
which is in page 20. To the officer in charge, police station Nahalagan, subject FIR. Sir, we have been receiving some fake appointment orders with forged signatures of the officers of the Director of Medical Education, TNR Nahalagan. You are requested to investigate into the case to find out the person or persons involved in the racket from the Director Office of Department of Health and Family Welfare, Nahalagan. We have come across fake appointment orders in the name of following candidates: Margam Rina so-and-so. This is for, so no any name of the accused person has been mentioned.
Mm.
After that, some fake appointment,
Who has filed this?
this
FIR?
by respondent number 2, 3, and 4. They are the directors of the health department.
Okay.
They have filed this FIR before the Nahalagan police station to unearth who are involved in the department
Mm.
for issuing a fake appointment. After that, case was registered and investigation goes on.
Mm.
During the entire investigation, no alleged accused person, petitioner for whom I am appearing,
Mm.
he was arrested only. There was a bank statement between the main accused person, Srimati Sangeeta Bansal.
Mm.
She was employed at Director of Family Welfare, there as a head assistant.
Mm.
He with she with other co-accused,
Mm.
they have took money from the people for the fake appointment job, and have prepared some fake seal and stamp of those directors, and they have issued the fake appointment. And I was only arrested only on the basis of suspect. This Srimati Sangeeta Bansal and I had a good relationship, and we had a commercial financial transaction, not regarding to fake appointment in the job case, but many occasions the accused Sangeeta Bansal have borrowed money from me. Only on the basis of that, when the bank account of the accused Sangeeta Bansal was confiscated, seized, freeze by the IO of the case. After they entering my name was, there was a different bank transaction between the accused Sangeeta Bansal and the petitioner. I was arrested. After entire investigation,
You are accused number?
I'm accused number 6, Sri Tajum Tama. And presently I'm working as a head constable, APPBN.
Okay.
I was informed by the I was informed and I was called by the Nahalagan police station during the time when I was before arrested, I was in fasting center at Sijusa Church. After hearing, I have cooperated. I have appeared before the Nalagan police station. After that, I was arrested. I got ill. I was in the medical. Again, after I was again re-arrested. I was in custody. After that, entire investigation has been gone. And if I take leadership to all the statement, 161 statement given by the accused as well as the witnesses, they are not a whisper or a single line sentence have been mentioned that the petitioner, I was involved in any way, mode, whether assisting, whether finance, whether issuing in the fake job record. So I was simply arrested on the basis of only bank transaction between one of the accused person. But after I was arrested and departmental inquiry proceeding was also initiated against me and all the accused persons, the IO of the case, they will be called before the inquiry board. Which I have filed one additional affidavit, Your Ladyship. In the additional affidavit, I have placed those inquiry report.
Of course, departmental proceeding and the criminal proceeding are two different things.
That cannot be in same equal footing. That, Your Ladyship, I agree. But here there is no any prima facie case established against the accused petitioner. As also in the departmental inquiry, I have specifically stated that he have not seized any incriminating materials, documents, anything and from possession from me. Only it was on the basis of just suspect, doubt, the bank transaction between me and one of the accused person. And all the accused persons were called before the inquiry board. None of them, they have admitted, they have stated that I was involved with them in any kind of form. If I may allow to read, Your Ladyship, the order also of the inquiry. If there is a thorough inquiry conducted, in a thorough inquiry, I have been exonerated after brief inquiry proceedings.
Okay, then.
I would like to place one case laws. This is a case laws of October 2025. Gurbhajan Singh Mata versus Central Bureau of Investigation. And
No, not this. Yes.
here also is a similar case related with this case, Your Lordship. There was some prevention of corruption charges was being registered against the petitioner. Later, after the inquiry, he was exonerated. No any prima facie.
Relevant para.
Relevant para, Your Ladyship, are para 2, 3. There are many paras altogether. I'm relying on para 2, 3, 21, 22, 23,
21, 22,
23,
23,
42, 43,
42, 43,
44, 47,
44,
48, 49, 51, 53, 54, 55, 57, 58, 59, and 60. And in this case, observation from of Radhesham Kejriwal versus State of West Bengal 2011, SEC, 3 SEC 551 Supreme Court observation was also been made.
What about the trial? At what stage is?
Trial, your ladyship, is still at the CC stage. The accused, main accused, Srimati Sangeeta Bansal, is not being appearing before the learned CGM court. For due that trial had been stuck at the stage of appearance come CC. Once she have appeared, that she is not appearing anymore. So I am now facing hardship. I am a government employee. I have regularly appeared during the trial of the case whenever the date is being fixed, called for, without any guilty of on my part. And the hearing of the case is next date is fixed on February 2, 2026. And your ladyship, trial have started from 22 August 2022. Till that proceeding is been stuck at appearance CC stage. And in between that, in 2025, the inquiry report conducted by the department has also been has been completed and an order has been passed, which I have annexed in my additional affidavit. And I has been exonerated from all the charges after thorough inquiry conducted by the inquiry board. If I read one of the paragraph of the Radhesham Supra case, that your ladyship, the same issue came up again after 3 judge bench in Radhesham Kejriwal Supra. The majority held that adjudicating proceedings and criminal prosecution are independent of each other. A finding in adjudication does not bind the criminal court. However, the court drew an important distinction where a person is exonerated in adjudication on technical grounds or because no penalty was imposed, criminal prosecution can continue. But if the adjudication proceedings, a clear finding is recorded that the allegations were wholly unsustainable and the person is innocent, then criminal prosecution on the same set of facts cannot be allowed to continue here. I'm not going to thorough with all the statement made by the your ladyship, by the accused and the witness. There are many, but if your ladyship goes in every of the alleged accused person, none of them have whispered or made any words or stated in the statement that I was involved in any form, your ladyship. So why I should be suffer? And this is a very fit case that your ladyship can exercise inherent power of 528 BNSS.
Okay.
In support of my case, I'm also relying on Bhajan Lal case. Your ladyship already aware there is.
Yes, Bhajanlal is always there. Then what about this Radhesham? Do you have Radhesham Kejriwal?
I have not separately placed, but it is mentioned in this judgment.
No, it is mentioned, but if you can provide that also, plus this Videocon Industries Limited versus State of Maharashtra also. Yes.
I have relied on Gurbhajan Singh Mata. This is a Matta versus CBI. This is the latest case of 2025 October, where there are many numerous case losses have been reflected. in support of my case. And Bhajanlal case also fits in this case.
Ticon Industries. No, the main issue here in your case is whether the exoneration in the departmental proceeding will lead to exoneration in the prosecution in the criminal case.
No, Your Lordship,
That is the question. That is the question.
if the learned trial court want any assistance or by the prosecution regarding the case, I will be there. But due to long delay of the trial proceeding, I have waited for long. If trial proceeding could have steep fast, I would have been discharged or I would been proved as not guilty. But due to the delay in the case, and I am a government employee, I am now a 50 plus age, a God-fearing person. I was not involved, which has been proved during the time of departmental inquiry. Even the IO of the case, he has given the statement that my arrest was only on the basis of suspect. So I pray this honorable court to do justice and exercise section 528 BNSS
Okay.
of inherent
Yes.
power of this court.
Who's appearing for the respondents?
I'm for 2, 3, and 4.
Okay.
This one, statement.
Okay.
Fantastic. Your Lordship,
I have gone through the the charge sheet also.
yes,
So,
charge sheet, this applicant was implicated.
implicated, but when you go through the entire
Yes.
charge sheet, I don't find anything.
Yes,
Don't
all
find
the
anything against
all the illegal appointees were also mentioned that they do not know this applicant.
That's why. That's why.
And transaction was shown as a loan transactions. There was a transaction, many transactions, documents of some transactions.
Between
not be-
the accused and that Sangeeta Bansal.
Yes,
But those are not connected to the appointment.
Yes, yes, already absolutely not connected.
yes. Probably it reveals that he was not connected.
Not connected.
Even
Those money were, in fact, the allegation is that those money were paid in order to get the fake appointment. That was the allegation.
That was the allegation.
Criminal machinery
Huh.
was given to on that basis.
But after the investigation process, they could not find anything
Otherwise,
connecting
there's no
connecting
statement of
the
allegation.
present accused to the case.
There's not only Sangeeta Bansal, there's one other accused with whom he has a transaction also. My lord, may kindly have page number 85 for a time. '85 is Jogin Sakya. He's one of the accused. And if my lord may kindly come down below, 17/3/2020, RTGS, check 5 lakhs. He is the main accused, in fact, one of the main accused. And thereafter, if my lord may kindly have page number.
This Jogin Saikya is accused number.
Jogan Saike, accused number 1.
Accused number 3.
Accused number 3, yes.
And if my lord may kindly have page number 86 again.
86. Yes.
Serial number 12, my lord, 16/9/2021. And again, there's a transaction of 1,50,000.
1,50,000.
Therefore, my lord may kindly have page number 89. That is in respect of the other accused, Sangeeta Bansal.
89.
My lord must have gone through that.
89. Yes.
Almost altogether, there are almost more than 35 lakhs of transaction. 17/10/2020, 14,500. Again, down below, my lord, 13/10/2020, there's a transaction of 5,50,000. 14/10/2020, there's a transaction of 5 lakhs. So, my lord, may kindly have page number 91. 91 also. 17/11/2020, there's a transaction of 5 lakhs. 18/11/2020, there's a transaction of 5 lakhs. 20/11/2020, there's a transaction of 50,000. Thereafter, if my lord may kindly have page number 92. 16/8/2021, there's a transaction of 2,50,000. Down below, my lord, serial number 14, I suppose.
Yes.
30/11/2021, there's a transaction of 2 lakhs again. Serial number 21, there's a transaction of 5 lakhs. Now, page number 93 again, my lord. (2012/2021), there's a transaction of 5 lakhs. Now, there's a transaction with 2 alleged accused by the present applicant, my lord. Whether my only contention is that whether it would be appropriate to have a mini trial to justify this and come to the conclusion that there's no possibility of conviction or leading to the conviction or acquittal at this stage. In fact, the charges were not framed at this stage itself. Therefore, my lord, I leave it to the discretion of my lord. Otherwise, rest, so far the witnesses are concerned, my lord, there's nothing as such incriminating against the present applicant, except the transactions. And the whole case has been built on the basis of this transaction.
See, all the fake appointees were also examined, isn't it?
Yes,
The
Your
fake
Ladyship, they have,
appointees were all examined.
they have examined, none of them
And
have
they
named
did not know the
Tajum Tama.
present applicant.
Yes,
So it is to be assumed that if some money is paid, it must be for his known person, his
Personal
relative or known person, whatever it
personal
may be.
person. No,
Any reasonable person would think that. So if they don't know him, then
Surprisingly, my lord, these 2 accused,
huh,
one is, both are the men accused, and there has been a transaction with them.
that transaction
And
is
we
there,
don't
no
know
doubt.
how they are linked in this case, how they are linked together and how they are known to each other. That has not been explained. So
Have
that
you
is-
explained what was this transaction all about?
he have
So many
he
transactions.
have cooperated totally, and he was in custody for more than month, Your Ladyship. And he have cooperated. Due to his cooperation, the IO have come to the conclusion after the charge sheet had been filed, no any incriminating materials have found out, and none of the accused and the witness have stated that he have paid those monies or he have collected from someone and use those money to pay them for the acquiring job. So I pray, Your Ladyship, this is a very fit case. Why
No. Have you
petitioner should
stated?
suffer?
Have you stated anywhere in the present petition also what this transaction was all about?
Yes, I have stated that it was a transaction for some contract works. Even the statement of the petitioner and the accused, Sangeeta Bansal's statement also has been stated there. If I allow, then I
In respect of only one accused. The other accused, there's no explanation as such. In this statement also, I've gone through this statement. There's no explanation to any extent stating that these are for this purpose. So that is the reason the charge sheet has been filed against.
Statement of prime accused Mrs. Sangeeta Bansal is at page 46 of petition.
46.
If I allow, Your Ladyship, I may read the statement, 161 statement of the Sangeeta Bansal. On being examining, the alleged accused stated, I am a staff in DHS. Prior to that, I was posted in the Department of Medical Education. I was aware that a huge number of posts were vacant in the DME, and it would soon be filled. I got in touch with directors of DME and DHS in the year 2018 and lobbied for fixing the job. They agreed to my personal proposal. After their agreement, I started collecting money from candidates. All the candidates were supplied to me by Tau Perry, along with one Dulom Yemi, and 1 or 2 more individuals whose name I am not aware of. I took a huge sum of money, and Tau Perry and others also collected huge sums as their commission on each candidate. I am not aware of the exact amount, but it must be in crores. Details of candidates and amount must be with Tau Peri. For each candidate for the post of MTS, I received 3,50,000, LDC 5 lakhs, UDC 7 lakhs, and other senior posts between 10 lakhs to 12 lakhs respectively, where Tau Peri collected a sum of rupees 8,50,000 for MTS, 10 lakh for LDC, 12 lakhs for UDC, and 15 lakhs, 20 lakhs for other posts. But before we could materialize our plan, APSSB was announced, and the directors who had promised to help us either were changed or develop cold feet. I started returning money to Tau Peri, but he told me that he is not in a position to return money as he had already used most of it. It is then that we thought of issuing fake appointment letter as candidate had started bounding us for their money and promised jobs. We thought that we will handle the fake appointment letter to the candidates and then deal with individuals DMO to keep them on jobs. And by the time they would draw salaries, we would try to negotiate a deal with directors. Further appointment letters were made on my computers at DHS. Tau Peri prepared the seals and distributed the letters to candidates, but this plan did not materialize as people became restless and verifying the appointment letters on their own. As soon as we heard that a case has been registered, I and Tau Peri fled, directing Jogen Soikia to lay low as well. Here, no, my name is there.
Explanation is at page number 54. Man. There is a statement of the main accused. 54 is the statement of the applicant who is before my lord.
Applicant, page number 50, statement of alleged accused person. On being examined, alleged accused 3. Sir, I am working as a head constable under only facts. Sir, in the year 2018, I met Sangeeta Bansal in the Director of Health Services, Narlagan, in connection with some work order. She was a dealing hand of DHS. Thereafter, I visited the office occasionally and got in good touch with her. I will not lie, sir. I had deposited some amount in her account and some amounts were in cash. That money were actually borrowed from my close relatives and lent to Sangeeta Bansal in higher interest rates. Later, I requested her to manage some supply order if possible. And on getting supply or work order, we had agreed to do work jointly. After lapse of 1 year, I told her that since it had become very late in getting supply order from the department or any work order could be obtained, I straightly demanded the entire amount should be returned to me. On this, she requested that she will return the borrowed amount in installment and if possible, try to help my unemployed relatives get appointment as contingency staff under Director of Health Service. Because of this, I submitted some document belonging to relative. That is all. But here nothing, your ladyship, there is any statement that I have influence or I was involved. If I take ladyship,
What
to the
about this
inquiry report-
Jokin Saikia?
Joken Road. Yes, your lord.
He did not say anything.
Just not
Okay,
anything to that extent.
Hmm.
My only contention is that because of that transaction, my lord, he has that circumstances he has been linked into this case.
Hmm.
Otherwise, apart from that, there's no statement as such
There's nothing.
incriminating or pointing fingers towards the accused. So
If I go read the statement given by Jogen Soikia also, there also my
And
name is not mentioned
if
anywhere.
we go by this Supreme Court orders, judgments in Radhesham Kejriwal and Videocon Industries, it says criminal prosecution and the same set of facts and circumstances cannot be allowed to continue. When it's same set of facts and circumstances, the DP was also held.
Yes,
Ah.
he held.
Yes.
But the departmental inquiry has a different conclusion, and this.
No,
there are
no,
different
of course,
allegations.
of course
There are
that is
different
there.
allegations in this case.
But there also in the DP, all the witnesses were examined there also.
Yes, ma'am. In departmental proceeding, my lord, only the statement of one accused, Sangeeta Bansal, has been taken into consideration and stated that it appears to be a loan amount. But in respect of the accused number 3,
That's
there's
Saikia.
no whisper at all. That is the reason. Rest
And what was the role of this Saikia? What did he do? Made arrangements with all.
he was the middleman, he was the broker man. We used to obtain money from the candidates
No,
and
no.
hand it over to the Sangeeta. hand it
Here,
over to Sangeeta
if
Bansal.
we go to the statement of Jogen Saikia, he was not the middleman, he was not the pimp. He have informed regarding there is a job vacancy to Tau Peri. Tau Peri was the middleman. who have borrowed those appointees. If I am not wrong, Your Ladyship, in the statement of Jogen Sarkar knew very well to Sangeeta Bansal since for last many decades.
Mm.
And Tao Peri and Jogen Sarkar were acquainted with each other. And in the 161 statement, Jogen Sarkar never stated that he borrowed money and collected from the appointees and given to Sangeeta Bansal. Rather, he have informed Tao Peri, the broker, who collected money from the candidates money was given to Sangeeta Bansal. Jogen Sarkar's role was that he just informed the Tao Peri.
Okay.
This applicant,
If even the IO have given in the statement also that during the time of course of investigation, IO have the power to arrest anybody on doubt suspect. That does not mean that after the thorough investigation, if no prima facie
Your Lordship,
a case built up against me or any incriminating materials filed
kindly peruse the page
I could-
37 of the
Page?
37 of the petition. It's a part of charge sheet,
Yes, yes.
second para. After necessary investigation, it has been found that the prima accused of the
Prime accused.
case, Mrs. Sangeeta Bansal, has been found involved in running racket
Past
property
many years.
for past many years. She used to show some notification to the parents and relatives of the unemployed job experience and make assurance that she will include the higher ups with the paid money. And the matter was kept secret for many years up to convincing the relatives of job seeker with one of the accused. However, when the things went out of the proportions in the month of October 2021, she was compelled to issue false appointment order with false signature government officials. Many persons were mobilized and allured by Sri Tao Peri, Ms. Sri Jogen Sarkar, and Tajum Tama. Many persons were allured by these three persons. And-
But who are these persons? Have they given any statement? That is the question. Have they given any statement against the
Allegation is against the applicant is only that he submitted applications for post appointment. Even in charge sheet also, and he includes as much as 11 and 25 persons respectively.
documents for 11
This para-
persons respectively?
From record, it reveals that IO could not establish the case against this applicant.
And that's why I'm saying that in the charge sheet, there is no incriminating material. Here, it says that the present accused has submitted documents for 11 and 25%. So he had also submitted some documents for
Yes.
some persons,
Uh,
but nothing happened.
Uh,
It appears that his candidates did not get anything. Isn't it?
Allegations is also that there is a transaction.
It appears that
which-
he may have tried to get some appointment for somebody, but nothing happened. It could not materialize.
Otherwise,
That's the general idea.
otherwise you're
correctly have mentioned that. I have already
Yes.
some money or from him to get. And Sangeeta Bansal in the statement, she herself has stated that she will provide some job vacancies to me. So,
Luckily for you, none of your candidates got the fake appointment.
I was very lucky. I am a God-fearing person. I believe in God. So
otherwise you
God have blessed me.
So-
Ladyship.
the present applicant, it seems that the statement of the present applicant, this
Truth always prevail, Your Ladyship.
Ah.
privacy established that this Sangeeta Bansal and Tajum this applicant,
Hmm.
where they were trying to obtain some work order. He asked for managing some work orders. That's why he lent money. That is
Work order.
intention. Both were the government servant.
There is no corruption regarding any work order, that there was any animosity.
And this is somewhere seems giving
Okay.
color to the
Okay, okay. We will dispose it. Heard learned counsel for the petitioner, Mr. Such and Such. Also heard learned your PP,
yes, additional PP.
additional PP,
Gitado.
J. Tado, for the state respondent. Also heard Mr. J. Chiring, learned counsel appearing, legal aid,
Amicus, madam.
amicus appearing for the respondent number 2 and 3,
2, 3, and 4.
2, 3, and 4. Okay, matter is disposed. We will dispose in the chamber. Okay?
Oblong.
Item number 5.
May it please, your ladyship, this
Yes.
is a bail application filed under section 483. 583.
Mm.
In connection with in connection with POXO case number 07 of 2019
Mm.
in Itanagar Women Police Station case number 28 of 2018.
Mm.
An offense is
The learned counsel for the petitioner shall supply copies of the petition on the learned legal aid counsel within 3 days.
yes, sir.
Within 3 days from today. So thereafter, list the matter after 1 week. After 1 week,
Yes, madam.
on the next date, the learned PP shall obtain the updated case diary. Yes, a scanned copy of the updated case diary. Yes.
Investigation.
No, but it's already charge sheeted.
Oh, charge sheeted.
Copy of
and-
TCR, madam.
Okay, in that case, registry shall call for the scanned copy of the trial court records
Yeah.
from the concerned court.
Yeah.
Yes.
Deeply obliged, madam.
Much.
Item number 6.
My lord, may I?
Mm.
My lord, this is bail application.
Mm.
My lord, I was released by this honorable court.
Mm.
Page number 20, my lord.
Page 20.
Yes, annexure 4. In this case, I was
Mm.
released. So
Then
after
what happened? Mm.
after executing the bail,
Mm.
my lord, page number 19, I'm taking the page number 19. Okay, annexure 3.
Page 19.
Annexure 3, para 4,
Hmm.
para 3.
Mm.
As may I?
Yes.
As accused Alif Islam is reportedly in judicial custody, issue custody warrant to the authority of jail for production before this court for face trial. To face trial. Since I have another case which was pending trial before the honorable court. So in this case,
Mm.
when I was in the jail, I couldn't appear before the honorable trial court for facing trial. So again, in this case, since this due to this order,
Mm.
order dated 3rd July 2000, I was again detained. So since then, I was for 7-8 months, I am in languishing in the judicial jail.
Mm.
So thereafter, I have applied bail application.
Wait.
Bail. Prepare bail before the honorable trial court. This is my lord, annexure 5, page 26.
Okay, wait. The bail which was granted by this court was in connection with section 21B NDPS.
Yes.
NDPS.
There I languished in jail for 1 year, 1 month. Yes.
So after that, the bail was granted.
Yes.
But during that time, you were still in custody in connection with another case.
Another case. So that's why I couldn't appear before the honorable court for facing trial.
So that means you had 3 cases pending.
No, two cases.
See, this one where the order was passed, this 3/7/2025.
Yes, yes,
This is session case 62 of 2022.
yes,
Okay.
yes,
Session case 62 of 2022.
yes,
62 of 2022.
yes,
So on this date, on 3/7/2025,
yes.
you were in custody in connection with which case?
In this, Your Honor, my lord, MDPS case,
Oh,
the-
acha, acha, acha.
yes,
Yes.
yes.
Uh,
Hmm.
on 3/7/2025, petitioner was in custody in connection with
23-24.
in connection with
Bandurga PS case 23-24.
DP's case. Mm. Case 21 of 2022. So that other Bandardewa PS case 23 of 24, has it been registered as session case
Yes, yes,
by now?
yes, yes. It's 62 session. Oh no,
No, no,
no,
no.
no, no, not. It's
No.
charge sheet has not yet been filed.
Oh, charge sheet not yet filed.
Yes,
Okay.
yes. My-
So that one was Bandardewa case 23 of 22. Um, And the present one is 21 of 21.
Yes, yes, present one. See, here, Your Honor, this custody warrant was there.
Yes.
On execution of that custody warrant, I have been again detained in
21 of 21.
jail, judicial jail.
Mm. Okay, then what happened?
Then Your Honor, prepare bail
Mm.
before the Honorable Session Court.
Mm.
Then bail has been rejected.
Let's see the rejection order.
Rejection order, your first bail rejection order. Your Honor, my lord, page
Page
25.
26. Oh.
Page 25. This is first one. Para 5, operative portion is para 5.
Yes.
May I have?
Hmm.
Had both the learned counsel and also perused the record of the case and found that the pending present case, the accused was again arrested by Bandurga police in connection with Bandurga PS so and so of the so and so after recovery of immediate quantity of contravention substance from his possession. Since that present case is at the stage of examination of accused person under section 313 of CRP, this court would like to dispose of the case early. So, para 6, bail has been rejected.
Hmm.
This is only the ground.
Hmm. Then subsequent one. again.
Subsequently, again, I have prepared one bail application. Page 27.
But here, while filing the bail application before the special court, you did not say that you did not give the reason that you were in custody, so you could not appear.
Yes, reason was given.
No, but nothing is stated here in the order.
This is the order of the case. In bail petition, it was pleaded case. Here also in, may I? In my petition also. My petition, para 5, my lord.
Your bail application?
Yes, yes. Bail application.
Mm. Mm.
Since the accused was languishing in the jail, so he lost contact with his counsel. Therefore, in this case, the Honorable Trial Court has couldn't be informed that he is languishing in the jail. Otherwise, he was appearing in that case regularly. Since the arrest in 23-24 case of NDPS, he couldn't appear before the court since he was inside the jail.
No, but you just go to this page 19, your annexure 3.
19.
Yes, annexure 3.
Hmm.
You're saying that as per this order, after this order, the warrant of arrest was issued. That's what you said,
Yes.
isn't it? But here, it only says accused as Alif Aslam is in judicial custody, issue custody warrant. That's all.
That's all, yes. But in execution of this, he has been again detained. That is the reason I couldn't understand, my lord. Then
No, this is custody warrant to produce you
Hmm.
for production to face trial.
yes,
That's all. It doesn't say to issue warrant of arrest or anything like that.
yes, but still then the jail authority has detained me. That is the case, Your Honor. Nothing.
May Lordship,
Ah.
there is the confusion regarding the name Lordship, because of the name. Lordship may go to the page 24 Lordship. The impugn order Lordship, 24 Lordship, page 24, annexure 5. The dated 24/9/25 Lordship order. Lordship, here this last part Lordship, the
Just-
accused, yes Lordship, this last three
It is submitted that Arif
yeah.
Islam and Alif Islam are the same
It
person.
regular, yes, Lordship. It is submitted Arif Islam and Alif Islam are the same person who was mistakenly reflected as Arif Islam by the Vanadeva PS number 2224. This is the PS number which is the Honorable Court has already granted bail, Lordship. On the dated Lordship 23/6/25.
In 23 of 2024.
Yes, Lordship. The Honorable Court, Lordship,
Hmm.
has already granted bail, Lordship. That bail order is annexure 4, Lordship, 20, page 20. Then, Lordship, here,
This is
Lordship,
Bandardewa case 23-24.
yes, yes, Lordship. Lordship, may I, Lordship, paragraph 3, Lordship, of this order, Lordship, of 24/9/25, Lordship. May I, Lordship,
Page.
page 24,
24, yes.
paragraph 3. Lordship, it is submitted by the learned counsel for the applicant that the accused Alif Islam is regularly attending the
Yes.
court to face trial in the present case. However, accused was unable to attend the court on 3/7/24, Lordship, because he was under Lordship, custody,
because he
Lordship.
was in
Yes,
custody.
till that time, the bail was not being granted by this honorable court.
Mm.
And accordingly, this court had issued bailable warrant of arrest of 2,000 to secure his attendance. The absence of accused was neither intentional or deliberate, but he was arrested by the Banadeva PS in the Banadeva PS number 2324 under NDPS Act, which was not in his knowledge regarding arrest of the accused, which he later came to know from the accused family relative, but in the said case, the Honorable Guwahati High Court has granted bail. Lordship, actually, the whole the story is that, Lordship, he was already granted bail. But the yes, Lordship,
But he
the
remained in custody.
he remained in custody. That's why he could not face the trial, Lordship. He could not attend the Lordship on the date, Lordship. And Lordship, in this order,
And
Lordship,
again, court has also made a mistake.
Yes,
The
Lordship.
trial court, it says that on 3/7/24, this court had issued bailable warrant of arrest.
Yes,
But it
Lordship.
was
Yes.
not bailable
Yes.
warrant
Yes,
of arrest,
Lordship.
actually.
Yes.
That's why, Lordship. And Lordship,
It was a custody warrant.
yes, Lordship. And moreover, Lordship, the cases, Lord, there's just two PS cases, Lordship. One PS case,
One
Lordship,
is 23 of 24, one is
and another 21 or
21.
22.
Yes.
And both the cases, they have clubbed together. And what Lordship has to see, Lordship, whether Lordship, this accused person need to be under custody again, Lordship. Actually, he was already been granted bail. So he was never been released from the jail custody, Lordship, judicial custody.
And this 21 of 21 is 395
Yes.
of 11
Yes, Lordship. 395 and 511 of IPC.
Examination of defense witness, Your Honor. Stage.
Sure. Okay. Heard learned counsel for the petitioner. We'll allow him to go then because
Yes, Lordship,
he's
because
understanding.
unnecessarily he is keeping him as a custody, Lordship. That the Lordship, he's been granted bail by this honorable court.
Yes.
Otherwise, also so many things has been violated. As per even
Anyway,
47,
we'll not go
48 is also violated.
Yes, heard learned counsel for the petitioner, such and such. So this is an application under section 483, read with section 71 of the BNSS, filed for release of the alleged accused person, Alif Islam, ALIF, Alif Islam, from judicial custody. Stop. Para heard learned counsel. No, you say in connection with judicial custody, in connection with
21.
in connection with session case number 62 of 2022,
22.
arising out of Bandardewa PS case number 21 of 21. Isn't it?
21 of
21
22,
of
Lordship.
20. He has
21
written-
of
he has written-
2022.
2021.
No.
No, 2021.
It's
20.
21 of 21.
Session case 70,
Session-
62, 20.
Session case is 62 of 22.
Yes.
Bandardewa PS case is 21 of 21.
Yeah.
Lordship.
21 of 21, huh?
Mm.
Under section 395/511 of the IPC, pending before the district and session judge Upia, Papumpare. Stop. Para. Heard learned counsel for the petitioner, Mr. Such and Such. Stop. Also heard MS L. Hagi learned additional public prosecutor for the state respondents. Stop. Para. The case of the petitioner herein is that the alleged accused person is undergoing trial in the session case 62 of 2022. 62 of 2022. No. Is undergoing trial in
62, Your my lord.
in the Bandardewa police station case number 21/21, being session case number 62, being registered as session case number 62/2022 under section 395/511 of the IPC. Stop. The accused person was attending the trial of the case except on a few unavoidable occasions. Stop. Para. The alleged accused during the while the trial was pending was again arrested in Bandardewa PS case number 23/2024 under section 21B of the NDPS Act. Stop. Since his arrest, the accused person lost contact with his counsel in the pending pending session case 62 of 2022. Stop. Para. The learned counsel for the petitioner submits that during the pendency, the accused person approached this court and by order dated 23/6/2025, 23/6/2025, in bail application 58 of 2025, he was granted bail in the Bandardewa PS case 23 of 2024. Stop. Despite the bail granted to the accused person, he continued to be in custody in session case 62. He continued to be in custody and was again taken into judicial custody in connection with session case number 62/2022. In execution of a custody warrant issued by order dated 3/7/2025 by the learned district and session judge Upia Papumpari. Stop.
3/7/2025, Lordship.
By an order dated 3/7/2025. Na? Stop. It is the submission of the learned counsel for the petitioner that on 3/7/2025 he was still in custody in connection with the Bandardewa PS case number 23 of 2024. Isn't it?
Yes,
Am I right? Yes, in 23 of 2024, and therefore he could not appear before the court on 3/7/2025. Stop. However, the learned session judge, the learned court below issued custody warrant on 3/7/2025 for production of the accused before the court. Stop. Accordingly, the accused was again arrested and forwarded to judicial custody. Stop. Thereafter, the accused again filed a bail application before the learned trial court, which was rejected. You say thereafter the accused filed subsequent bail applications. You filed two, no?
Yeah, two bail
Subsequent bail applications before the learned trial court, which were rejected by order dated 24/9/2025 and order dated 2/12/2025. Stop. The petitioner has therefore approached this court in this bail application, praying for release of the accused person on bail. Stop. Para. The learned counsel for the petitioner submits that the accused person has two cases pending trial against him in the court of the learned district and session judge Upia. Stop. The first case is the session case number 62/2022, arising out of Bandardewa PS case number 21 of 21. And the second case is the Bandardewa PS case number 23 of 2024, in which he has already been granted bail by this court. Stop. In the first case, the name of the accused is reflected as Alif Islam, ALIF, Alif Islam. And in the latter case, his name is reflected as Arif Islam, ARIF, Arif Islam. Stop. During the due to which the misunderstanding may have arisen, and the council and the learned council submits that the petition that the official name of the accused person is Alif Islam, ALIF. Okay, Alif Islam. Stop. It is further stated that the accused person is languishing in custody since his arrest on 8/4/2024 till date. And the accused person has spent more than 1 year, 10 months in
1 year,
custody.
5 months and 16 days, Lordship.
1 year,
5
5 months.
Now to Lordship, it can be kind of 10 months more, Lordship. This order passed on 9, Lordship.
Yes. So it must be 1 year, 10 months only.
Yes, Lordship.
Has spent more than 1 year, 10 months in judicial custody. Stop. Stop. It is further submitted that the accused is ready to abide by any conditions if released on bail, and undertakes to attend the trial as and when summoned by the court. Stop. Para. This court, the learned additional PP has also fairly submitted that the as on 3/7/2025, when the learned session judge passed the order of custody warrant, the accused was in custody in connection with the Bandar Dewa PS case 23 of 2024, and therefore he could not have appeared before the court as he was in custody. Stop. The bail was granted by this court only on 23. Wait. 23/6/2025, you were granted bail, isn't
Yes.
it? 23/6/2025. Then on 3/7/2025,
There was custody warrant.
custody warrant was issued,
Yes.
but you were not released.
He
But
was
I was
remained
because
remained
of
in the
this
bail,
problem.
yes,
Yes,
Lordship.
yes.
Because they could not communicate
That is
properly.
okay.
Lordship.
Okay.
Now my lord has got
Okay. Okay, it was very confusing.
Yes.
As on 3/7/2025, when the order was passed by the learned session judge, the accused person was still in custody, even though he had been granted bail by this court by order dated 23/6/2025 in BA 58 of 2025, due to the misunderstanding in the name of the accused person.
Lordship, may kindly reflect the PS number also, Lordship. Bandar Dewa PS number 2324.
Uh-huh.
Oh, yeah.
As on 3/7 such, he was in custody, even though released on bail by an order dated 23/6/25 in BA 58 of 2025,
In Bandar Dewa.
in Bandar Dewa PS case number 23 of 2024.
Yes,
Okay.
sir.
Stop. And therefore, she fairly submits that there must have been some misunderstanding due to the due to the difference in the name,
Yes,
due to
Lordship.
the difference in the name of the accused person,
Where it is reflected in the BA 5825 as a Arif Islam, Lordship.
as to whether the petitioner's name was Arif Islam or
Or
Alif
Alif Islam.
Islam. Stop. Para. This court has considered the submission of the parties and has perused the reports and also the trial court records which are produced. Stop. It appears that there has been some misunderstanding with regard to the actual name of the accused person, which has been used as Arif Islam in some documents and as Alif Islam in other documents. Stop. However, in the present application, the electoral photo identity card, EPIC, na? The EPIC card of the alleged accused person has been produced, wherein his name is shown as Alif Islam, ALIF, Alif Islam. Stop. And it is seen that no, but even the bail application, in your bail, that bail application 58 also, it's written Arif.
Yes, Lordship.
That earlier counsel has committed mistake, my lord.
Lordship,
it,
here-
even page 30 also, my lord, NRC. This is the final citizen register certificate, NRC, page 30, serial number 4. Alif Islam.
If Lordship go to the records, Lordship, records also, Lordship, the this Lordship concern court, Lordship below, na, they have recorded Alif versus Arif. Two name was
Oh,
recorded,
Alif,
Lordship.
alias.
Yes, alias, Lordship.
Arif is just pet name.
They've also been recorded as a two names, Lordship.
Okay.
That means that they are both are same.
In the EPIC, it is shown as Alif Islam, okay, ALIF, Alif Islam. Whereas in the bail application 58 of 2025, the name of the accused person was shown as Arif Islam, ARIF, Arif Islam. Stop. However, upon going through the trial court records and the connected police records, it is seen that Arif Islam and Alif Islam are the same person.
Same person.
Yes. Are the same person. And even in the order sheets of the learned session judge, it is seen that the name of the accused person is reflected as Alif, ALIF, alias Arif Islam. Stop. Therefore, the present accused person had been granted bail by this court on 23/6/2025 in BA 58 of 2025 in connection with Bandar Dewa PS case number 23 of 2025. Stop. It is also seen that by order dated 3/7/2025, the learned session judge had issued a custody warrant for production of the accused before the court, and it was not a bailable warrant of arrest. Stop. This court is of the view, therefore, that the misunderstanding was caused merely due to the use of two different names in respect of the petitioner, in respect of the accused person, which has caused the confusion. Stop. It is therefore the view of this court that the accused person may be released on bail at this stage on the following terms and conditions. Stop. Before that, you say PP has also not disputed the fact that the accused person has now been in custody for more than 1 year, 10 months. Stop. Then after that, you say that he may be released on bail on the following conditions. Number one, the accused shall execute a bail bond of rupees 30,000 with one local surety. With one local.
My lord, 30,000 is too high. I'm a mere driver only.
Too high.
Right.
20,000 then. 20,000 with one local surety of like amount to the satisfaction of the learned trial court. Number two, the accused shall appear before the court for the trial and be present on every date fixed. Stop. Number three, the accused shall not you are a resident of UP only, na?
No, I'm a resident of Harmuti.
Okay. Anyway, the accused shall not leave the jurisdiction of the trial court without the leave of the court. So, with the above directions, this application stands disposed. The registry shall send back the trial court.
My lord, just one correction.
Yes.
This Harmuti is not within the jurisdiction of trial learned court.
So, whenever you want to leave, you just put in an application
And before the.
before the trial court.
Yes,
No
Lordship.
problem.
Lordship, then, Lordship, this bail application for the session case number 6222, Lordship.
Yeah.
Otherwise, they will also, again, they will make confusion, Lordship, whether for the
Yes.
23, 24 or 21, Lordship.
It is just in the end, last para, you say it is made clear that the present bail application, that the present bail granted is in connection with the Bandardewa case 21 of 21.
21, yes, Lordship.
21
And
of
session
21.
case
Session
number
60.
In session case 62 of 22.
Okay.
Yes, Lordship. Much obliged, Lordship.
Item number 7.
May Your Lordship.
Mhm.
Your Lordship, here service report in respect of respondent number 2 and 3 are still waiting. Therefore, I may be allowed to take fresh steps. And Your Lordship, moreover, the respondent number 1 is also yet to file their counter affidavit.
Learned counsel for the petitioner, Mr. Sergeant Such, is present and submits that the service is not completed in respect of respondent number 2 and 3. Stop. Moreover, the respondent number 1 is also yet to file the affidavit in opposition. Stop. The learned counsel therefore pleads for permission to take fresh steps on respondent number 2 and 3. And prays for listing the matter after 3
3
weeks.
weeks. I'm appearing for the respondent number 1.
Okay, learned counsel, Mr. Such and Such, your name appears for respondent number 1. Are you filing your counter?
Yes, my lord, I will file our reply in the next hearing.
Okay. Also prays for some time to file his counter affidavit. Stop. Accordingly, list the matter after 3 weeks, and the learned counsel for the petitioner is allowed to take fresh steps on the respondent number 2 and 3.
Your Lordship, there is an interim order may
The
continue.
interim order passed earlier shall continue till the next date.
Much obliged.
Item number 9.
Lordship, the respondent, they have filed their affidavit in petition, Lordship. Lordship, I may be allowed to file a rejoinder in their affidavit, Lordship.
Reply.
Yes, rejoinder in the reply.
Learned counsel for the petitioner, Mr. Your name?
Yes.
K. Taso.
No, R. Ingo.
So such is present. Stop. It is submitted that the affidavit in opposition on behalf of the respondent has been filed, and he has received a copy of the same and would like some time to file a rejoinder to the counter affidavit of the respondents. Stop. Accordingly, prayers allowed list after
4 weeks.
after 4 weeks. Stop.
Lordship, there is an interim entry.
Learned counsel for the respondent. You are for respondent number
T tagam por L parme.
and such. Appearing for respondent number.
Sole respondent.
Oh,
Sole
sole respondent appears for the sole respondent. Okay. So the interim order passed earlier shall continue till the next date list after 4 weeks.
Reply applied.
Item number 10.
None appears for the petitioner when the matter is called list after 1 week.
Item number 11.
Item 11. None appears for the petitioner when the matter is called list after a week.
Item number 12.
Yes.
May I please, Your Lordship?
Hmm.
Your Lordship, this IA is filed for implement of informant, Your Lordship.
Okay.
That is Kavita Duggar, Your Lordship.
The present application has been filed by the petitioner praying for impletement of Srimati Kavita Dugar, Kavita Dugar, Dugar, as a respondent in criminal revision petition number 35/2025. Stop. Heard learned counsel for the petitioner who submits that the petitioner has filed a criminal revision petition number 35/2025 before this court, challenging the impugned order dated 8/8/2025 passed by the learned district in session judge Upia. Stop. It is stated that during the course of hearing, this court, vide order dated 28/10/2025, had made an observation that the complainant/informant should be made as a necessary party in the criminal revision petition 35/2025, and hence the present application has been filed. Stop. It is stated that the failure to implead the complainant/informant is an inadvertent mistake and was due to oversight. Therefore, it is prayed that the respondent number 2 may be that the complainant may be allowed to be impleaded as respondent number 2 in the criminal revision petition 35/2025. Stop. Upon considering the prayer of the petitioner, the same is allowed, and the petitioner shall file an amended cause title reflecting the name of the complainant as respondent number 2 in criminal revision petition 35/2025, and thereafter take steps for notice on the respondent number 2 by inland speed document as well as usual process within 3 days. Thereafter, the matter may be listed after 3 weeks. 3 weeks. After 3 weeks.
Your Lordship, kindly, it may be, service may be taken within 1 week, Your Lordship, because today is Thursday and Friday, Saturday, Sunday.
No, I said working days.
Okay.
Within 3 working days.
Your Lordship, item number.
Beg your pardon, my Lord.
Yes.
Item number, I'm appearing item 10, my Lord. We are just outside, my Lord, but I missed it, my Lord. Item 10, my Lord, I'm appearing for the petitioner.
Oh, acha.
So here, my Lord, I've gone through the records, my Lord. It's the record reveals that after taking the steps, the copies and the notice was received by the respondent number 2 for all the respondents, man. So received, my Lord. It was received by the respondent number 2, my Lord, as per the records, my Lord. Now, my Lord may observe that and my Lord, and let them give some opportunity, my Lord.
Okay.
Otherwise, it
In
was
item
completed
10,
in.
In item 10, instead of petitioner, I think I said petitioner is absent, na? So you delete that and you say learned counsel for the petitioner, Mr. D. Soki, na?
My Lord.
So D. Soki is present. Stop. The office note dated 28/1/2026 indicates that the AD card has been returned back to the registry after due service on respondent number 1 to 9. Stop. Accordingly, the service on respondent 1 to 9 is deemed served. Stop. However, none appears for the respondent when the matter is called, least after 3 weeks,
And my lord,
awaiting the appearance of the respondent.
there is an interim order, my lord, that may
The
be continued.
interim order passed earlier shall continue till the next date.
Oh, right.
Your Lordship, in item number 11, Your Lordship, we have just missed the matter, Your Lordship. Your Lordship, in item number 11, what has happened was that earlier when the notice was issued and the record was called for, the registry was directed to call for the record, Your Lordship. Subsequently, when the matter came up on 21st of January, this 26, Your Lordship, we have been instructed to take a written instruction or record from the respondent number 2, Your Lordship. Your Lordship, if Your Lordship allows us, because we have not been served with an extra copy to be given to the executive magistrate, Your Lordship.
Oh.
And the communication from this court was only given to us on 23rd, 24th was holiday, 25, 26 holiday. So the information we could give the information only on 27 without the petition copy, Your Lordship. So the party may be allowed to serve us a extra copy so that we can take a proper instruction.
You give extra copy?
My lord, as per I remember, the copy has been served. If under record, what is the item?
No, Your Lordship, on the first occasion, the registry was directed to call for the record. It was only on 21st/1/2026 that we have been directed by this honorable court.
My lord, in this regard, only it will take only 5 minutes. On the same order was passed on 21st/10/2025 also, similar order. Call for the records from the office of executive magistrate to remove. Least after 2 weeks.
That was the
And then again on recent in the 21 January 2026 also same order. It doesn't just keep lingering. And last time also I had submitted the similar position of the case that I have the records. The LPC is very clear. And this is just wastage of precious time of the honorable court only, because if they had any authority, they would come and.
No, but Learned PP is saying that the magistrate has not received the copy.
Yes, because on the first date, it was direction to the registry, not to us, Your Lordship. If Your Lordship, you see the first, when the matter had come on the first occasion, on 17/9/25, there was nothing as to calling for the record, Your Lordship. Subsequently, the matter came up on 21/10/2025, Your Lordship.
Yes, my lord.
That's when the record was called for.
Acha, and who accepted notice for respondent 2 and 3?
2, it was us, Your
respondent
Lordship. 3 had also appeared, and they they sought time to file their affidavit, but then none of them has appeared today, nor affidavit has been filed.
Till then, none of them had appeared.
So requisite copies, the petitioner should have served 2 copies.
Because
One
on the
for
first
DC and one for the executive magistrate.
because on the first
That was
occasion,
not served.
yes, on the first occasion, because the notice, because the record was to be called from the registry, we had not taken any extra copies. It was only on 21st of this month, Your Lordship, when Your Lordship has directed us to call for the records.
The learned counsel for the petitioner, Mr. M. Nibo, is present. Stop. Learned government advocate, additional public prosecutor, Miss Ginny.
Yes, Your Lordship.
Ginny is present and submits that the respondent number, that the petitioner has not served an extra copy of the petition for the respondent number 2, and accordingly the same could not be served on the executive magistrate / respondent number 2. It is also stated that when this application was moved on 17/9/2025, the court had called for the records through the registry of this court. It is therefore prayed that some time may be given to receive the required instruction, and that the petitioner may be directed to serve an extra copy of the petition for onward transmission to the respondent number 2. Stop. Accordingly, the petitioner is directed to serve one copy, to serve one extra copy of the petition to the learned additional PP to be served on the respondent number 2, and thereafter the necessary instructions as to whether the land of the petitioner is situated in ICR capital region or the
Circle.
or the Doimuk circle shall be obtained by the learned additional PP on the next date. Yes, and also the records of the titles to number 27/2020.
But that is nothing to do with this.
Okay, then delete the title suit one. Okay.
And
Fix on.
On 16th of February, Your Lordship.
16th of February 2025. 26.
Interim may continue earlier.
The interim order passed earlier shall continue till the next date. This is item 11. Okay, item 11.
Lordship, may Lordship.
Yes.
Lordship, in the item number, Lordship, today's 13 and 14, Lordship. The Lordship, the petitioner person, Lordship, he requested me to adjourn this matter as he has some health problem, Lordship. He left the court.
Oh.
So it
When-
may be
when do you
listed
want?
after
2 weeks.
2 weeks, Lordship. Yes, Lordship.
Item 13 and 14.
And
It is prayed on behalf of the learned counsel for the petitioner to list the matter after 2 weeks, as the learned counsel has some health issues
difficulty,
today and had to leave the court.
Lordship, 16 and 17 also, his name is reflected, Lordship.
Yes, this is Bulu Ramdas.
Yes, Lordship.
Learned counsel, you just put his name also, as he has some health issues today. So prayers a lot list after 2 weeks.
Lordship.
We'll just say list after 2 weeks. Yes.
Much obliged, Lordship.
Yes. Yes.
Item number 22, it's an unlisted matter. Criminal petition 5 of 2026.
Pardon? Yes, someone was mentioning this. You want to withdraw, no?
Yes, Your Lordship.
Okay.
Your Lordship,
With liberty to file.
yes,
Okay.
Your Lordship.
Learned counsel for the petitioner, Miss such and such, who has prayed for withdrawal of the present petition with the liberty to file a fresh. Stop. Para. The prayer is allowed. The petition is disposed of upon withdrawal. The petitioner is at liberty to file a fresh application if so advised. Yes. Applies.
Item number 15,
Mediation.
My lordship.
Yes.
Lordship, there were two petition, similar petition, arising out of same FIR.
Okay.
So the matter was referred to the mediation
Hmm.
on last occasion on 22nd
Could not be
September.
settled.
No, one has been already set aside.
Oh, one
now,
settled.
yes. So, during that time, this present petition, the petitioner were not entered into the mutual settlement. Lordship. Now they have already settled the matter. Lordship.
Okay.
The settlement.
Yes, my lord. I'm appearing on behalf of respondent number 4 and 5. My lord, since the matter has been amicably settled between the party, on the last occasion itself, on 1st August 2025, it was reported to the mediation, and that connected case, similar case, it was already disposed.
Okay.
But due to the absence of the petitioner in this case, it was not settled. So, however, it has been settled now, and the settlement report also is with us, if I may produce.
Okay.
Yes.
So you want this court to dispose, or you will refer it to the mediation and dispose there?
My lord, it's better to dispose of it since the respondent number 4, her husband has died recently, and also she's a single mother. So if this matter goes continue, though, it will be
Why you're
hectic for.
three different affidavits? What is this?
My lord, the other two is the following agreement of the settlement deed. One is the main is the settlement deed,
Then
and the other is the undertaking,
taking.
and then apology, which was agreed by the parties.
At the outset, the learned counsel for the petitioner, you are for the petitioner.
Yes,
For the petitioner, such and such submits that this matter had been filed along with another criminal petition, being criminal petition number
225 of 23.
225 AP 2023, which was referred for mediation along with the present case. And during the mediation process, the matter in criminal petition 225 AP 2025 was settled between the parties and disposed of. Stop. Accordingly, however, the petitioner in the present case could not appear, is it?
Yeah.
Could not appear before the mediator during the mediation process, and therefore this matter has been referred back to the court. Stop. Today, when the matter is called, the learned counsel for the respondent number
Respondent 4 and 5, my lord.
number 4 and 5 in the present application has produced a copy of the settlement deed dated 29th January 2026, executed between the complainant and the accused persons, and also an undertaking dated undertaking 18/11/2025 by the accused person.
Yes,
Gandhi
yes.
Para is the accused.
Yes, my lord.
By the accused person.
Your Lord,
Yes.
I'll just put small, I'll apprise this court because if this matter, if being sent to the mediation is proper, why? Because all the matters, all the sections in this matter are compoundable, Your Lordship. Now, under 482, compoundable matters cannot be disposed of.
Yes. That is one thing. That is one
So
hindrance.
it may be sent to the
So it's
mediation.
best if we refer it and then you settle it there like the other case.
Yes.
My lord,
I'll fix a date next.
in other way, it can be done in that way also, but the parties itself in the last mediation trial, they have already agreed to dispose of. So therefore, we request that here itself.
No, it's the same thing whether it's disposed by this court or by the
Yes, my
mediator.
lord. Yes, my lord.
But the thing is, if it's compoundable offense, then 482 will not come.
Yes.
That is the problem. So you delete, okay. But only that part where I've said that settlement, this and that. No? Or we can say settlement, anyway, you just continue. And undertaking by the accused person, then the council has also, learned council has also produced an apology letter. Apology letter executed by the accused person. Stop. In view of the above settlement deed, undertaking and the apology letter, learned counsel for the parties submit that the matter may be disposed of by this court. Stop. At this stage, the learned public prosecutor, Ms. T. Ginny, has submitted that all the offences are compoundable in nature, and therefore, the question of maintainability under section 482 CRPC /528 BNSS is to be considered by the court, and therefore praise that the matter may be referred for mediation. Stop. The court has considered the submission of the parties and has duly noted the submission made by the learned public prosecutor. Upon going through the record, it is seen that all the offences that the offences involved in the present case is under 448/323/341 IPC, which are compoundable in nature, and therefore it would not be proper for the court to entertain the application under section 482 CRPC/528 BNSS. So accordingly, the matter is referred for mediation under the nationwide mediation drive. Stop. The matter is referred to the Guwahati High Court Mediation Center, Itanagar Bench, Naharlagun. Stop. The parties shall appear before the mediator when? Next week.
Next week, yeah.
Next week.
Give a date. I think that is better.
Any fixed date may be given.
Shall appear before the mediator on 4th February 2026, and
Very
thereafter
Yeah, 45, yeah.
and thereafter the mediator shall
Okay, my lord.
do the
Fourth
needful.
Feb.
Shall do the needful.
Much obliged.
You can take this back and
Yeah, yes.
produce it before the mediator. Okay.
Item number 18.
You give it back to the advocate. Yes, sir.
My lord, matter may be referred to mediation tribunal.
May or may not be.
Yes,
May be referred.
yes, yes.
Heard learned counsel for the petitioner. You are for the petitioner, isn't it?
Yes, Your Honor.
For the petitioner, no, but is the respondent appearing? Respondent has entered appearance.
No, Your Honor.
Then first the respondent has to enter appearance, then only mediation can carry on. Otherwise, if only you are appearing, then how can the mediation take place? Notice is not complete.
No, this is not. Oh.
Learned counsel for the petitioner, Mr. Sergeant is present. Stop. It appears that the service of notice upon the respondent 2 to 6 is not yet has not yet returned. Stop. Accordingly, list after 1 week, awaiting service report on the respondent number 2 to 6. Yes. Done.
Finish.
Okay, good.
Thank you.